Welcome to our 15-minute webinar series brought to you by the Government Affairs Committee. I'm Michael Mulcrone, the Executive Director here at BOMA Suburban Chicago. On behalf of the Board of Directors and the Government Affairs Committee, thank you for taking time from your busy schedules to participate in this seminar. A couple of housekeeping things. This webinar is being recorded and will be posted on the BOMA Suburban Chicago website and our YouTube channel as soon as we can download it. In addition, we will send the presentation to everyone who is registered. Because we only have 15 minutes and we have 113 registrants, we will not be taking live questions. Please send your questions via the chat function. There's a button that should be at the bottom of your screen. Send your questions via the chat function, or you can send it to my email address at michaelm@BOMA Suburban Chicago. Now, let me introduce Susan. Susan Atkins is an attorney with Smith, Gambrill, and Russell, and she's coming to us live this morning from Atlanta. So good morning, Susan.
Good morning, and it's Atkinson, S-O-N. But
oh, Atkinson, I'm sorry.
That's okay. So my guess is that I'm speaking to mostly Chicago people. I hope you are able to understand my Southern accent without the need for a translator. And I see just from the pictures that I can see on the screen that we have some people who look like they're in the office and some people who look like they are working from home. So congratulations to all of the above. Michael says that he has had many questions about the applicability or what commercial property managers need to do pursuant to HIPAA. I think HIPAA is one of those things that everybody's heard of. Everybody knows it's a thing. It has to do with privacy of medical information. But if you haven't had to, delve into it previously, because usually your usual work doesn't have anything to do with medical information, you haven't really had to think about what it does and doesn't require. So that is where we're going to start. And Michael, if we could go to the next slide. So this is essentially what Michael says he's been hearing. Help! I don't know anything about HIPAA. Okay, so let's just do a really brief review of HIPAA. HIPAA is a federal statute. As you may have heard, it has many extensive requirements for the protection of the privacy and security of individually identifiable health information, which is generally referred to as PHI, or protected health information. HIPAA only applies to, and I have in quotes, covered entities, which is a defined term in the statute, and it only includes health plans, like health insurance plans, healthcare clearinghouses, and those are entities that do bundling of medical claims, and healthcare providers, and their, quote, business associates, which is also a defined term. So as you can see from this definition of covered entities, commercial property managers are not HIPAA covered entities. Okay, next slide, please. Michael, there you go. No, go back. Okay, there you go. So, like I said, it also applies to business associates. So, are you a business associate? A business associate is a person or an entity who does work for a covered entity that requires access or use of the protected health information. So I've got this example here. Hospital hires an outside company to do their medical billing. Well, obviously, this billing company has to have access to protected health information because they're billing the medical claim. It shows the person's diagnosis. It shows what kind of medical treatment they had, et cetera. So that's an instance where that company is a business associate and there are specific requirements about the business associate agreement and that sort of thing. But the good news for you is commercial property managers also are not business associates. Next slide, please. So to get to the nut of the original question, yay, HIPAA does not apply to any of you. However, that doesn't mean that you don't have some legal responsibilities relative to confidentiality of COVID-19 related information that may come to your attention. You have legal responsibilities to your tenants, And one thing you may not necessarily have thought of, you have legal responsibilities to your own employees to the extent that they are on site at the properties. So, you know, the question of what are my responsibilities relative to the confidentiality of this medical information sort of begs the question of, well, how did I become aware of this medical information to begin with? And you do want to know this information, and we'll get into that in a minute. But the answer is how you get the information is you should use the tools that are available to you in the lease. I've never seen a commercial lease that did not have the rules and regulations of the property and the ability of the landlord to update or change the rules and regulations and you know, send them out to the tenants, and the tenants have to comply with them. So that is a tool that is available to you. Next slide, please, Michael. So tenant communications are important, and this certainly isn't mandatory, but it is certainly recommended due to, sorry, gotta make my phone go away. Sorry. Tenant relations, you know, you want to make sure that everybody feels comfortable, but you also have these obligations to your own employees, which we'll talk about in a minute. So in addition to this rules and regulations change, you should, our recommendation is that you be very proactive in your communication with, I said residents, but tenants, about your plan, your notification plan. So on the one hand, you use your rules and regulations to say, you know, until further notice, the rules and regulations of this building are going to require each tenant to notify the landlord or the property manager of any COVID-19 infection among its employees. But then you give this proactive communication to them about what are you going to do with that information. You give them a commitment that you're going to maintain confidentiality of you know, the identity of individuals, which of course is going to enhance the likelihood that they'll actually comply. And then you tell them how you're going to go about communicating what has happened. That plan would essentially be the second bullet, which you're going to notify everybody in the event of a potential or actual exposure in the building. Now, right now, I am on mandatory work from home, but we were on voluntary work from home for a period of time when I did work from home. And during that time frame, I received several notifications from my employer, which forwarded communications from our property manager. These communications said, we've been notified of a diagnosis of COVID-19 by a tenant on X floor in the building. So my employer then went on to say, and they're in the different elevator bank from us, so we don't have to worry about having touched the elevator button or whatever. You know, so in other words, we would receive these notifications from the property manager. It didn't say, and it was Susan Atkinson, age 57. You know, they didn't give any information like that. They just let us know enough to know what sort of health impact it could have on the tenants and their employees. Okay, so like I said, these communications aren't mandatory, but we recommend that you put that out there to the tenants, what we're going to do, you know, with their notifications, and then you actually notify them, like I said, if something actually comes up. Next slide. So what are your if you don't have to have HIPAA obligations, what are your legal obligations? So you have these obligations to your employees as well as the tenants. So employees, the Occupational Safety and Health Act, which you've probably all heard of, OSHA, generally imposes a responsibility on employers to provide their employees with a, quote, safe workplace. And that includes safety from known risks, which obviously COVID-19 is. So this is going to be applicable to the property manager for your employees, and it's also going to be applicable to the tenants for their employees. Now, there are other legal obligations related to employees, which we don't have time to get into today in our 15 minutes, but just know that relative to your interactions with your employees, there are other legal obligations that you need to pay attention to relative to, if you have an employee who either is infected or you think may be infected, EEOC requirements under the Americans with Disability Act, that sort of thing. So just know that is also a thing. But for today, we're just going to focus on the OSHA issue. Okay, next slide, please. So what are your legal obligations to tenants? Well, you've got overall responsibility for safety of the premises, and I'm sure there's probably something in your lease about that. Also, pretty much all commercial leases have a section about maintaining the confidentiality of quote unquote confidential information. So particularly if you've sent out this communication that we talked about promising confidentiality of an individual's identity, then this information would it's very likely that it would be subject to that confidential information requirement in the lease. So in terms of identifying individuals, even though you don't have this HIPAA responsibility, nonetheless, basically you shouldn't do it because of your lease obligations. Next slide, please. So there are a number of ways to stay informed about, sort of what's going on in the world of coronavirus. The CDC has a dedicated web page which covers all sorts of things. I just gave the general page here, but within that page, if you search around a little bit, there's something called interim guidance for businesses, I think it is, and it has a lot of great information about basically what businesses should be doing during this pandemic state of emergency. Another great way to stay informed is to carefully monitor announcements from your local and state public health officials and elected officials such as mayors and governors. One thing that many people don't know is that although we get a lot of information from the CDC, in a state of public health emergency, the CDC is not the decision maker. The state and local public health departments are the decision makers, and the CDC is support for them. So notwithstanding the fact that there's a lot of good information coming out of the CDC, the most important thing for you to look at in your local area is the state and local announcements. Okay, so we are at 10:16, and I think we started at 10:03, so I know that I've zipped through a lot of information. But to do a quick summary, you are not subject to HIPAA. You do have responsibilities to your employees. You do have legal responsibilities to your tenants relative to confidential information. And probably the best course of action right now for the safety of all is to amend your rules and regulations, if you haven't already done so, to require tenants to notify you of any actual infections and communicate with the rest of the tenants in a confidential way. That is what I have for today. And I understand that there may be questions for, let me see, there's one chat question. Oh, this just says any questions. Okay, so.
Yeah, that's me. So,
okay. Go ahead, Michael.
Yeah, so anyway, if you have any questions, send them to the chat or send them to my email, michaelm@BOMA Suburban Chicago.